Good afternoon and good evening to all participants. My name is Thomas Drachler and I'm Associate Legal Officer at UNCITRAL. I would like to give the floor to my senior colleague, Mr. José Angelo Estrella Faria, Principal Legal Officer and Head of the Legislative Branch of UNCITRAL, who will be moderating this webinar. Thank you very much.
Thank you very much, Thomas, and greetings to all participants. Good morning, good afternoon, and good evening, ladies and gentlemen, and welcome to the second day of our webinar on international experience with the dematerialization of negotiable transport documents. Yesterday, we had in the first session a general discussion of the legal framework for dematerialization of transferable records. We had on the second panel a discussion more focused on the impact of dematerialization in banking practices and the advances being made already by the banking sector. We will focus today on the transport industry, and we have two panels. One panel, the second one, which is slightly larger and longer in duration, devoted exclusively to the maritime sector, and the first panel to carriage of goods by air, rail, and road. I would now, without further ado, like to introduce the speakers to our first panel. They are Mr. David Solve, who is a manager with the digital cargo team of IATA, driving the digital transformation of the air cargo industry. He has over 10 years of experience of business transformation, innovation, and project management, and currently he's working on innovative solutions for the airline industry to enable data sharing among air cargo stakeholders and to make air cargo talk with the use of connected devices. The second speaker representing the rail industry is Mr. Eric Eftimov. Mr. Eric Eftimov is the Deputy Secretary General of the International Rail Transport Committee, CIT, where he had served as senior legal advisor since 2004. He's also the chairman of the CIT OSJD, CIM SMGS Legal and Expert Group, and of the CIT Working Group on Multimodality. He's also a lecturer in various universities, and he has participated in previous expert group meetings of UNCITRAL devoted to the proposal for the development of a possible future instrument on negotiable multimodal transport documents. The third speaker is Mr. Jens Hugel. Mr. Jens Hugel is a senior advisor at the International Road Unit, IRU. He joined IRU in 2001 as head of economic affairs and later became head of economic affairs, road safety, and international transport. He currently heads the sustainable development and goods transport section of IRU and has done so since 2008. He's also not unknown to UNCITRAL since he had represented RAU during the negotiation of the Rotterdam rules. So now, without further ado, I will invite the first speaker of our panel, Mr. David Solve, to make his presentation. David, please, the floor is yours.
Good morning, good afternoon, good evening. Thank you, Angelo. Should I share my presentation with?
Yes, please.
Let me know if you see my screen.
Yes, we can.
And we're good to go. So thank you very much for having me here today. What I would like to do here is to share with you a bit of our journey in the digitalizations of our transportation documents, and in particular about the airway bill and the electronic airway bill. So as you know, today international trade is about moving goods. But it's also about moving informations, sharing informations through the different parties. And informations are more and more important for the transportation of goods. Today in the air cargo industry, we have estimated that every year we transport about 8,000 tons of paper, documents that are processed, and this is the equivalent of 80 Boeing 747 freighters. And as you can imagine, this is a lot of paper documentations. In 2005, to address this topic of digitalizations and paper documents, IATA kicked off the e-freight program, which is an e-freight industry-wide program that enables to build an end-to-end paperless process without having the need to transport and use this paper anymore through the use of electronic message standards. So the scope would include any stakeholders from the shipper to the consignee, including freight forwarders, ground handling agents, airlines, and customs authorities. Back then, the objective was pretty ambitious because we had the ambition that by 2010, all the paper would be out of the cargo industry. That would be able to generate 1.2 billion US dollars savings every year, and that would enable to reduce the shipping time by 25% down to 4 days. Also, what we looked at are the benefits for the industry. Obviously, we talked about reducing the shipping time, and here the objective was to also bring operational efficiency that would enable to reduce that shipping time. Also, as we would not need to process a paper document as well, we would expect cost effectiveness, better cost effectiveness and optimizations, along with the better use of data and having a better data quality, in the sense where we are not going to have paper documents that we need to process, but instead electronic messages where we can automatically capture the information. Also, we believed that with the freight, we will be able to open doors for innovations through standardizations and digitizations, and that would enable the development of value-added services for all the air freight community, from the shipper to the consignee. As well, we've seen that every year the air cargo transport a lot of paper documents, and of course, in terms of sustainability, e-freight will enable to reduce the use of paper. And finally, today we all know that customs administrations more and more require advanced cargo informations for risk assessment and security, and e-freight enable to do that. So the e-freight program is based on 3 pillars. The first one is the customs documents. Then the second one is the transportation documents. And the third one is the commercial and special cargo documents. So in this presentation, I will focus on the transport documents, and particularly on the airway bill. So the airway bill is a critical document for the air cargo, because this is the contract of carriage between the shipper and the carrier. And this document, in terms of form and content, is governed by IATA resolutions, and particularly the resolution 600A, which define the airway bill, and the 600B, which define the airway bill conditions of contract. When it comes to the electronic airway bill, which is the electronic version of the paper contract, within IATA and the member airlines, we developed specific resolutions, which is the airway bill resolution 672, called also the multilateral airway bill agreement, which enables to remove the requirement for a paper airway bill. And basically, this document aims to capture the consent of the shipper to use electronic informations, electronic messages, instead of the paper. And then it means that the original transportation contract would be in an electronic form, what we call the shipment record. And therefore, there is no need to print or transport the paper document. When we look at the paper document versus the electronic version of it, so in the paper document, we have a front with the content of the contract. And this is the part that is governed by the resolution 600A. And then we have the reverse that defines all the condition of carriage. And this is what is defined and governed by the resolution 600B. In the electronic world, the front of the document would be materialized through the electronic message standard that we defined. So basically, this is where you're going to have all the information about the shipment, about the consignee, about the carrier, about the terms of the contract, and so on. And the back of the contract, which is the condition of carriage, which will be managed through the multilateral e-CMR agreement, where all the different stakeholders sign it once with IATA, and then they are able to use this agreement with all the different stakeholders. So when it comes to the electronic message standard, today we have two different standards that is currently being used. The first one is the cargo IMP, which is the first standard that we developed. And then we developed the cargo XML standard based on XML schemas, which bring additional features to the old cargo IMP standard. So today, the cargo IMP standard is no longer maintained, even though it's still being used, but only the cargo XML standard is currently maintained. So basically, with the electronic airway bill, the freight forwarder will be able to initiate the message with all the content of the shipment. Then this message will be sent to the airlines. The airlines will be able to send back a message to the forwarder to acknowledge the receipt of that message. And the airline will be as well able to send a status message that will conclude the electronic contract. And then this message will be able to be transferred to the ground handling agent so that the ground handling agent can have all the information about the shipment and being able to process the shipment accordingly. Also, the use of electronic airway bill is only feasible thanks to the international conventions, particularly the Montreal Conventions from 1999 that has been developed by ICAO, the International Civil Aviation Organizations. And MC99, as we call it, is intended to replace all the different patchwork of regimes that has been developed since the Warsaw Convention in 1929. MC99 has been entered into force in 2003, and it governs liability for passengers, baggage, and cargo on international flights. And particularly, it defines the liability in terms of death, injury, or delay to passengers, delay, loss, or damage to baggage, delay, loss, or damage to cargo. We are currently continuing with IATA and ICAO to promote the ratification of MC99 with the different parties. And today we have 137 parties that already signed the Montreal Conventions. And as we can see here, the Montreal Conventions is a modern and fair conventions in the sense where, from a shipper point of view, it increased the liability, the coverage of the liability of the shipment in case of damage, from about $20 per kilo with the Warsaw Conventions to $31 per kilo with the Montreal Conventions. Also, the use of electronic airway bill is only feasible since the Montreal Conventions of 1975, and also this is the case with the Montreal Conventions of 1999. So the way it works is that the use of airway bill so electronic airway bill, is feasible between what we called feasible trade lanes. So these are countries, a couple of countries that signed the same international treaty. So either two countries who signed MC99, or two countries who signed the Montreal Protocol number 4, the MP4. So if it doesn't, if the trade lane is not covered by any of these international conventions, EAO bill is not feasible because, as we've seen, only MP4 and MC99 allows the use of electronic airway bill. Also, there is a note to mention here that even though international regulatory framework allows for the use of EAO bill, we've seen that in some countries, local customs authorities still require the paper document for their internal process. And this is also one of the challenges that we face, and that also is a challenge for the airway bill adoptions, because then it means that they need to know and understand the local regulations and when a paper still needs to be bring with the shipment. Today, the global penetration of EAO bill is about 72%. And as you can see here in the regional breakdown, there is a slight differences between the different regions. And you can see that in the Middle East, and this is where we have the highest adoption rate. And in Americas, that contains so North America, Central America, and South America. This is where we have the slowest adoption rate with only 53.2%. So when we look back at the air cargo digital transformation journey, in 2005, we kicked off the e-freight program with some pretty ambitious objective. And when we look at the situation in 2020, we have almost, so overall we have about 70% EAO bill penetration. When it comes to the other document that is in scope of the e-freight program, this is not very significant. We still see a lot of paper being transported for other type of documents. And the observation is that the shipping time door to door is still at 5 to 5 days, which is not the objective that we had back then. When we look at one of the reasons why it has been so challenging since the last 15 years is that what we did is that we only did a digitization in the way where we only took a paper document and just try to make an electronic version of it. And actually what we observe is that this is what is refraining the industry to move faster. With the messaging standard, also we had some challenges where the message is transferred from one party to another. And as you've seen with all the different stakeholders, it became quickly a big challenge in terms of governance, in terms of traceability. For instance, when a party either on purpose or by mistake made a change, it's very difficult to know where that change has been done. And if a part of the message has been truncated for some reasons, it is also very difficult to know that in advance. It means that in terms of data quality, some people don't trust very much the electronic message, and therefore they still bring the paper document with the shipment that creates a dual process, the paper process on the one hand and the electronic process on the other hand. So therefore, if we want to fully embrace the digital transformations, we believe that the industry needs to get rid of the documentary flow to speed up the cargo flow. And instead of focusing on the document itself as an input, focusing on the data element as an input. And therefore, we kicked off in 2018 a new standard, which is called One Record, which is our new data sharing standard that I will going to introduce to you right now. So as I mentioned, One Record concept is to move from a peer-to-peer messaging model to a data sharing model relying on a virtual shipment record. So basically, not relying anymore on this peer-to-peer message, but more having a virtual shipment record made of different data elements that the different stakeholders would be able to share on the internet through the use of API. So this virtual shipment record is based on 3 pillars. One is the data model, which defines the what I want to share with my different business stakeholders. And then the second is the API standard that defines the how I will be able to share that information through the use of web technologies. And finally, the last one, but not the least important, is the security part, which enables to define with whom I want to share my data. So it really will enable to build a trusted network of partners. So with One Record, we want to move, as I mentioned, from a document-centric model that we have today with the messaging standard to a data-centric model that will enable to provide a better visibility and transparency, will improve data quality and remove duplicate. Because we know that today we have several documents that contain the same type of information or supposedly the same informations, but we know that sometimes there are discrepancy. And for instance, when a customs authority receives a paper airway bill with some informations and house airway bill with information that are supposed to be the same but are different, this is where we have some issue and where a shipment are blocked. So with the One Record, what we want to do is to really capture the data at the source of the data owner, and then with the use of the data, being able to generate whatever document could be needed. So it might be the master airway bill, the house airway bill, or any other types of document, but generating this document based on a common source of data to avoid all these data issues and discrepancies. The key benefit that we see with this new data sharing standard is a better data quality and control. As the data is shared by the data owner, that the data owner will have a full control of the data, and the data will stay at the source, and the data owner will determine who will have access to this data. Also, it will enable us to increase the visibility and the transparency, as we want to include the end-to-end transportation chain, and that we will be able to share the data with the relevant parties as soon as the data is available, and not needing to wait that the previous stakeholders send the message. Also, we want to increase the connectivity with all the different stakeholders with the plug and play notion, in the sense where with standard APIs, it will be easier to connect the different parties. Today, when you have an IT equipment, as long as you know that you have USB port, you know that you will be able to use your device. And this is the same that we want to achieve here. And also what we want to achieve with these new standards is to build a true foundations for digital air cargo that will enable the use and the sharing of the data, so that people, they will be able to develop new value-added services that will improve the air cargo industry. And finally, the last point is about welcoming the new generations, because today, when you want to hire grad students, they are all used to work in a digital environment, and you cannot expect them or you cannot expect to attract them in your industry if you're still using processes that are from 1970s with technology that has been developed by their grandparents. And definitely we need to offer something attractive to our new generations. So the last word that I would like to share is that in the transportation industry, if we want to move forward and to embrace innovations and technology, we need to stop looking back and stop looking back at what we used to do with the paper, stop saying that it works like this, so we can still continue to work like that, but looking ahead where this future is. Thank you very much.
Thank you very much, David. I think it was a wonderful presentation and very intrigued about many of the aspects of what you've described. I've written down several questions, as I guess also the other participants will have done the same. Now I will have questions at the end, but now I'll give the floor to Eric for the railway perspective. Eric, please.
Thank you very much, Angelo, for giving me the floor, and also for the invitation of the CIT to present further on additional information on the electronic consignment node SIM SMGS. And also thank you very much for the support of the UNCITRAL Secretariat of the work of the CIT and the other railway organizations, OSGD and OTIF. Please, next slide. Thank you very much. In addition, information on the railway transportation between China and Europe, and why actually the proposal of China is now focusing on rail. Just as a background, we start already to reflect this new possibility besides traditional modes of transportation like air transport and maritime transport on a global level. Now, for a very first time, we have a possibility to have a global rail transportation on a very long distances, connecting the dots between production and the consumption of goods. That's why here now is a question how to bridge the various legal regimes for speeding up a possibility for a new performance of rail. The very first and important step in this connection was also the access of China to the handbook for the consignment node SIM SMGS, starting 1st of May 2017. Why this access to the document SIM SMGS is so important for rail? On the next slide is the handbook bridging the two legal regimes. Just a very short information on why rail is so important to have this legal interface and bridging the two legal regimes. In difference to air transport and road transport, and afterwards a maritime transport, in rail we have since many years two different legal regimes with different liability, different documents, and also how to be conclude the contract. So for this purpose, CIT together with the OSGD produced on a sector level a coherent document, which also UNCITRAL presented in the very important background document for the last meeting. So here, just a very short information how the contract of carriage based on the consignment node SIM SMGS can be organized in two different legal regimes. On the next slide, we have the important legal base of the handbook for the consignment node SIM SMGS in the sense of a sector solution with two different transport contracts, but we have a coherent documentation which is also reflecting and preserving the liability regimes in the existing regulations, the consignment, the convention SMGS and the uniform rules CM. So this is an addition to the thoughts of Professor Guyot, in the sense that the consignment note, the common consignment note CM SMGS, is a legal interface, a bridge between two applicable regulations respecting the existing liability regimes. This is the first important conclusion, I think, for our further discussions, how documentation can be also produced as a transferable document with additional functionalities, one of which is the accreditive functions, because this is what is new in the 21st century, especially for rail, to provide the global services for further facilitation of trade and transport. On the next slide, thank you very much for the full screen presentation. We have just visualization of the common consignment note CM-SMGS, the paper version, which is based on the layout key for transport and trade documents produced by UNCTAD, and combining the trade and transport functionalities. So now for us, for the discussion, it's important to reflect how we can proactive use the functionalities for accreditive of the document, of the transport document. Just to remember our discussion, this document is a sum of the two transport contracts, SMGS and CIM, and also have functionalities for customs purposes, also evident of the two transport contracts, and also, as yesterday informed for the colleagues from ICC, is included in the handbook UCP 600 for accredited documents for banks. So in our understanding, we can use CIM SMGS also as a bank document supporting the transportation between China and Europe. Now, the reflection should be how this document can be also used proactively for the additional function transferring this document from one consignee to another one without changing the liability provisions in the existing mandatory provisions of the conventions SMGS and COTIF CIM first, and second, we are not looking here in this discussion for the function title of rights on the goods, because for the transport contract is not important primarily who is the owner of the goods. Once again, just a second summing up from the legal point of view, the transport contract is always a secondary contract in a transaction, which the first originally contract is the contract of selling and buying goods, where we have also the point of ownership on the goods. The next slide is just showing how important this common coherent document for rail is, living in the dual legal system. For now, we have almost all container transportation in Eurasian corridor covered by this single document. So the railway transportation is really needing coherent system for performing better with additional possibility, reducing also red tapes and insecurity. For a single wagon load, because we have a different transport modes of transportation as well, container and single wagon load, we are still by 20%, and we have facilitation of the whole transportation in time, and also providing a higher security for the whole transportation. This is the original, the starting point for this work. So now the second step in the project is how all this facilitation can be organized digitally in the 21st century if we conclude with the 20th century on paper. The next slide is the starting reflection on the digitalization of the transport documents, how in the handbook for the electronic consignment note, SIM-SMGS, the provisions are. We have, first of all, explicit background, legal background for the consignment note SIM-SMGS as a common consignment note in electronic version based on the functional equivalent in the SIM provisions, and also the contract between the consigner, consignee, and the carrier in the sense of SMGS. So what was presented by the colleague of IATA, in our understanding, it can be the ADI agreement, which is on the second page of the electronic consignment note, supporting the possibility for exchange of data between the participants of the carriage, the sender of the goods, the carriers, the contractual carrier and the carriers, and also the consignee. And on this background, legal background, CIT together with OECD already prepared functionalities which are in the sense of legal and functional specifications for the content and exchange of data, and also technical specifications for exchange of this data between the participants to the data flows. In our case, once again, we have some additional necessity to produce converter between the various functionalities in the two legal regimes. Still, we have from one side technical specifications for the consignment note SIM based on XML data, and on the other side for the specification of the SMGS consignment note based on EDIFACT. But still, in the document, which is a coherent document for the functionalities, you can find it also on the web page of the CIT and the OECD. You can see a coherent common functionalities for the electronic consignment note for the purpose of the consignment note SIM SMGS, also in a technical specifications. The next folio is showing the document, this coherent document, as a background for the electronic consignment note in the triage of the functional specifications, legal specifications, and technical specifications, which are provided and put in place together with OECD on 1st of July 2019. So now, why we are so interested in the project of UNCITRAL, because on the next folio slide, you can see how we can move further for the practical implementation of the electronic consignment note on the corridors in deploying various pilot transportation. This is a stage for the moment where we wish to find railway undertakings which can use the existing documentation for the electronic consignment note to organize rollouts of rail transportation on a very long distance, also using the coherent specifications. And this is for sure, in our understanding, a good starting point for functionalities which can be also in the sense of accreditive. This is an additional function which we can understand as a possibility for additional accreditive financial support by the banks for trade first, and secondly, transport facilitations. In our case, the documentation, the transport documentation, SMGS is in the handbook UCP 600. So as a back document, we have to test it. Also important rollout understanding and the conclusions from the pilot should be how the electronic consignment note should be introduced on the level of exchange of data with the authorities, especially customs authorities in China, for the customs union, Russia, Belarus, and Kazakhstan, and for the European Union. This is a second very important test run. And the third important test run is how to interlink the additional accompanying documents. Because we start already yesterday to reflect, is not just the possibility to have one single solution for a document. We need a digital environment, and it was expressed very nicely yesterday. It's not enough to have one phone. It's necessary to have a network where we can connect these phones, and in this case exactly the same. We have to reflect how the transport documents can be introduced in a digital environment with the functionalities which the transport documents can provide. One is evident of the transport contract based on the original selling contract. Further to that, improving the functionalities as a bank document, important accredited function, because only on this way we can have additional financing investment in rail transport, in cargo transport between Asia and Europe, and also reflect for seamless exchange of data with customs authorities. And what about the accompanying documents? Because for the moment, and this is also my question to our colleagues from the other transport modes, how to deal with the accompanying documents, which are mainly in a paper version. And in this case, if we have to downgrade, and the next slide is a nice example for the long distance transportation, about 12,000 kilometers between China and the United Kingdom, and this is a real railway transport, even to the island, running through the Eurotunnel. So we have 12,000 kilometers for about 17 days. And there, I think now the challenge is to reflect in the project of UNCITRAL on the next slide, which we would like to go further for providing a multimodal negotiable transport document for transportation outside of maritime transportation on a first stage, but always thinking that we have absolutely to connect the ports and to include maritime transportation, because this is the performance of the global trade by maritime transportation. It's about more than 90%, and this is very important also to include the maritime transportation into the reflections of a new multimodal negotiable transport document. And here, once again, the second point of reflection is how we can use the idea of a dual track. So to use upgraded transport documents with additional functions, especially on the interface to banks, insurance companies, also very important, customs, security agencies, and on this way, providing additional possibility for negotiability, transferable possibilities for the participating parties to the transport contracts, which is absolutely necessary in the 21st century from the prospect of rail, because this is a business case where we can achieve a higher performance carrying goods between Asia and Europe on a direct railway link, which is a new challenge, but also a new business possibility for rail. On this way, thank you very much for your interest. Thank you very much for your support. And we are open for further discussions on all open questions. Thank you once again.
Thank you very much, Eric, for your presentation and also for the questions you are asking. I mean, the last question on the involvement of the maritime lag would then provide also leeway for the following panel. But before we get that, we have our last speaker for this panel, Jens Hügel. Jens, please.
Ladies and gentlemen, distinguished delegates, it's a great pleasure for me to address this virtual audience on a virtual topic. And I would like to thank specifically UNCITRAL for inviting the IAU and for reaching out to the road transport industry on this very important topic. Thanks a lot for this. With the next slide, I would like to give a short overview of the IAU, because I feel that many of you might not know us. The IAU is the World Road Transport Organization that represents 3.5 million transport companies. So we are a membership-based organization. We have transport associations, but also large companies in our business portfolio. And we are present in more than 80 countries. Next slide, please. I would like to start to set the scene from a slightly different angle. And that is, I would like to start with highlighting the dramatic impact of COVID-19 on the road transport sector. If you look at the impact of the COVID-19 on the road transport turnover, we had to deal and to cope last year with a decline of $1 trillion in turnover, which translate into a loss of more than 18%. The most pressing issue at the moment for transport operators is a liquidity problem. And if you look at early insolvency indicators, they all show we're confronted with a looming wave of bankruptcies. Well, actually, I have to correct myself. Latest figures from last week show actually that we are not anymore have a looming wave of bankruptcies, but that we rather have a wave of bankruptcies that is now approaching the transport sector. And here my crucial question on this slide. Is this the right moment to introduce yet another standard for transportation documents? Next slide, please. We have at our disposal already tried and tested tools. UN conventions, including the TIER convention, that's a custom convention, and the e-CMR convention, both have already digital tools, IT tools, and they exist, they're tried and tested. And just let me read out a quote from the UN Secretariat General, which you can also see on the slide. Tools such as the UN TIER convention and e-CMR system that allow to exchange electronic information without physical contact and facilitate the flow of goods across borders should be used. This is really important at the moment for the transport sector to address COVID-19 and also looking into the future to build back better. Because by using these tools, we will not have a disruption in supply chains, we will protect our drivers, and we will have a good electronic exchange system of data. Next slide, please. Here I would like to do a little historic tour with you and look back to 1956 when the e-CMR convention was born. And I have to say it's quite of a strange animal because The CMR convention regulates private law. So it looks into the legal obligation between consignor and consignee in the road transport sector. You have the convention, but you have to turn it into a real-life operation, and that's the reason why already in 1976 we developed a CMR model consignment note, and we worked together here with the ICC at that time. And this note that you can see here on display on the slide is actually now mostly used by transport operators in the countries that have ratified the CMR convention. And you can see also here on the slide on the right those countries who have ratified and who are implementing the CMR convention at this moment. On the next slide, we do a little jump to the year 2008, when the CMR convention was amended and an electronic consignment note protocol was added to it. At the beginning in 2008, there were just 5 countries who ratified the system and said this is a good tool for us. With the appearance of the mobile phone, a couple years later, it became a huge boost, and transport operators wanted the electronic solution. Governments wanted the electronic solutions. International organizations wanted this solution. And alone within the last 3 years, we have 15 countries who joined and ratified the e-CMR protocol. Here on the slide on the right, you see a map again. Germany was one of the white spots there. And as a matter of fact, they are on the brink of ratifying the e-CMR protocol as well. On the next slide, you can see that there's a huge protocol to turn a paper-based tool into a digital tool. Just looking at Europe, there are currently 9 billion CMRs used in national and international transport. 9 billion paper documents turned into 9 billion messages. Now, why do transport operators want this? And on the next slide, you see the reasons for this. Transport operators see the benefit of faster administration, faster invoicing, the reduction of the delivery into reception discrepancies, but also transparency is a very important asset for transport operators. They want to see where the goods are. They want to control and monitoring the shipment. They have real-time access, and they want to make sure that ultimately the data are correct. On the next slide, you see why governments want this. And here we do support governments in the implementation step. Governments, nationally, but also organized in international organizations such as the UNEC, UNCEFAC, but also UNCITRAL. And again, thank you for UNCITRAL for being such a good partner in this discussion. They see the benefit of turning the paper into an electronic solution because they see also the added value around that. They see there is an added value when it comes to customs declaration services. You can link it to other services. You can also link it to safety. e-CMR could be linked to an e-safe, an e-call tool, which immediately gives notification to emergency services when an accident happens, and they know immediately what kind of goods are loaded. So there are a lot of added values around this e-CMR tool, and that's the reason why governments want that, and that's the reason why we also work together with the international organizations to get this done and operational. On the next slide, you see that several governments and companies are already implementing it. In Turkey, in France, in Russia, in Iran, I could extend this list with many other countries. There are already tailored and tested e-CMR solutions in the market. On the bottom, you see a little graph how it would work. And sometimes it's just a simple QR code on the phone that is sufficient to replace a paper document with an electronic solution. Now, Eric Eftimov from CIT said, well, it's good to have a phone and it's good to have a network. I would like to add something. It's even more important to have different solutions, different providers, be it Deutsche Telekom, be it Swisscom, be it Austrian Telekom. There are different solutions, and we are technology neutral. We want the transport operators have the best solutions. There are tried and tested solutions in the market at the moment. We heard from the airline industry, they have a good solution. We heard from CIT, they're working on a good solution. In the transport sector, we have a good solution. And then I come back to my question that I had at the beginning. Is this the right moment to look into yet another standard, yet another global solution, and try to harmonize this? And I know my colleagues from UNCITRAL might not like this statement, but I think maybe it's not the right moment to do it right now. With this, I would like to close my presentation with the last slide. I'm there for any questions that you might have. I'm also there to answer your concerns or issues. Thank you very much for your attention.
Thank you very much, Jens, and thank you also very much for your candid opinion about the opportunity for the development of an additional instrument and on multimodal transport documents. And also thank you for the kind words to UNCITRAL. You will probably recall that UNCITRAL was actively involved in the drafting of the additional protocol to the CMR. At that point in time, the UNEC had reached out to us, and also was a privilege for me also to have been personally also involved in that process, and I'm very glad to see the high level of implementation of it so far. We have, it's now 10:30, we would have 5 minutes for questions. And as I've done, as I did yesterday, and I see here one question in the chat, and I'll read out the question. Is addressed to Eric and David, and asking them to expand on whether IATA and CIT efforts to digitize airway bills or consignment notes have addressed the financing of the goods governed by these documents of title, in particular the challenges for banks of taking security over goods by control or possession of documents without paper on IATA CIT systems. I think Eric already addressed partly this by mentioning that indeed consignment notes are non-negotiable documents, but I leave that at. This is the question that was addressed to the two of you by one of the participants. So who would like to go first? David?
Yes, for me, quickly, I think the answer would be the same in the sense where the airway bill today is not a negotiable document nor a title of property. It is just a contract of carriage between two different parties.
Thank you very much for the question. I think we can, and this is very important question to reflect how further we can cooperate with the bank sector, because if it's a successful story for maritime transportation, I have the impression on a global level, it should be also a success story for the other transport modes, in the sense that we can look on the interface between transport and financing, a creditive function to the transport, in the sense that if the transport document is also included in the UCP 600, we have to provide additional possibility for the clients to use these documents in extenso in the function of accreditive. So the question is probably also to the colleagues from the bank sector, how, and yesterday we had very interesting information from the colleagues of Commerzbank and the other ICC representatives, how we can proactively use this possibility also for transport sector, because if the question of China is on the table, this is for sure somewhere we need to look into the gray zone of the interface. So not because I'm interested always in problems, but for sure, if we have this pertinent question, we oblige as international fora to give a proper answer especially for facilitating trade and transport on a global level.
Thank you very much. I would like to ask one question pending receipt of other questions from participants. And it would be addressed to all the three of you. We know that neither the airway bill nor the consignment notes, be they road or rail, are documents of title as such. However, all of them are in an interface with the underlying sales contract. And the question that I'll be asking is, whether any of the systems that the organizations have devised for electronic transport documents, where we have contemplated the possibility of alteration of data that is entered in the contract, in particular as it regards delivery of the goods, or whether instructions can be given to the carrier after the shipment of the goods while they're in transit. I appreciate that it's probably less likely to affect the air industry, but if we're talking about a railway transportation of 17 days, maybe things can happen in the sales contract in the meantime that might, where the parties might wish to be able to give instructions to the carrier. Is this, I don't recall hearing anything about this in your presentations, and I appreciate if you could add some information on that. So, Eric?
Yes, sorry, to start, you mentioned our performance in 17 days, which is exactly the new possibility to reflect on the rail contract. Because before, living in the two separate legal regimes, it was a transportation which is lasted no more than 2 days. So this is exactly where we have a new business solution, a new opportunity to perform on a global level between Asia and Europe. So this is exactly where we have also to reflect how the contract organizing the transportation for 17 days on 12,000 and more kilometers, we have to answer to the necessity of the clients. So it's into the legal regime that the sender, the consignor, can change the contract. So this is, or can change the consignee. So this should be also reflected in respectively in the document, which is evident of the contract based on the conventions. The question is, I think, to reflect additional functionalities for the transferable transport document. This is the first question which we, I think, have to reflect. And the second one is here, if we wish to discuss the title of rights, but this is something which is additional discussion. It's not direct linked to, for the moment, for the transferability of the transport document, because the non-negotiable transport document is not per se title of rights. This is so somehow we have to start step by step, looking on the various questions which are dealing with the various functionalities of the transport contract, because we have a new challenges, and one of them is how to solve the possibility to for the transport document, in our case the railway consignment note, to be transferable to another consignee which is not the original one, by using, for example, the duplicate of the consignment note. If you can imagine that the consignment note is a bunch of various, this is in paper, in electronic, the same functionalities. So one of the functionalities is the duplicate, which can be transferred to a new consignee. and we can provide these functionalities in addition to the existing transport contract. This is the one reflection on the sense of changing in transit the contract and reflecting the changes into the transport document.
Thank you very much, Eric. Dave, Jens, would you like to add? Jens, please?
Yes, if I might to add something. First of all, I agree with what Eric said. If there are changes in the transport that of the goods that are transported, they also need to be changes reflected in the consignment note. But I feel the thrust of that question went a little differently. It went like, what happened if, for example, goods are lost during the course of the transport? 17 days for rail transport, maybe a few days for the road transport sector. And then we go into the question of liability. And here I would like to highlight why, and I come back to my statement, it's the right moment to come up with something new, multimodal, why there are difficulties for the road transport sector to have a multimodal approach. If a transport good, like a cargo, is lost on the way, normally there's a compensation of about 875, 900 euros for one goods package lost. Now imagine a whole truck is on a ship. The ship sinks. Only the goods are secure, only the goods are insured, and you get per package 875 euros back. The vehicle is not insured at all in this circumstance under the CMR consignment note and under the Rotterdam rules in that case. So I feel there are difficulties when it comes to the detail, liability question and so on and so forth, to ensure that the security is taken care of, that the safety is taken care of, that the needs of the transport operators are taken care of, and that the financial implication ultimately is taken care of. Thank you.
Thank you, Jens. David, would like to add anything to?
Yes, I just wanted to add a short comment on our side. As we mentioned that on our side, the transportation document is not a negotiable document nor a title of property. We are more focused on the data sharing because it is essential for the movement of the goods and to be able to process all these informations. And that's why for us, we are less concerned about less focused on these document vision, but rather what we would like to aim for is to be able to capture those data elements, because what we believe is that if for some reason we need to generate a document based on the data elements that has been captured and shared with the different stakeholders, we will be able to generate these documents. And also it's the same when there is a change in the shipment, either the shipment is different, has been modified, or there is a change in the flight allocations or so on. As we are managing data, it will be easier to have update in the shipment record. It's going to be easier to have the latest update of the shipment. And for that, we wouldn't need to change the different documents. But as we have the data, the source, then the document will be able to be automatically regenerated and updated.
Excellent. Thank you very much. Now, ladies and gentlemen, we are a bit over the time, but we're still on time to have our break and come back punctually at 10:50, which is the time when the next panel would start. I thank you all who join me for a round of virtual applause to our speakers, David, Eric, and Jens, for their very interesting, thorough, and thought-provoking presentations. Thank you very much. We now take a 7 minutes break and we'll be back at 10:50. Thank you. Ladies and gentlemen, welcome back to the second panel this morning. We have 4 distinguished speakers in this second panel. As announce to you, it's a slightly larger panel than the previous one, because this one is really focusing on the electronic equivalent of negotiable transfer documents, which is at the very core of our webinar. The first speaker to address us today is Alexander von Ziegler. Professor Alexander von Ziegler is a former Secretary General both of the Union of Marine Insurance, IUMI, as well as the Comité Maritime International, CMI. He is also a professor for international trade, transport, and maritime law at the University of Zurich. He's a partner Schellenberg-Wittmer's Dispute Resolution Group in Zurich. He has been a member in many international working groups and working parties on harmonization of transport and commercial law, and he's also currently the delegate of Switzerland to UNCITRAL Working Group 6 that is currently discussing judicial sale of ships. The second speaker is Paul Mellon. Paul Mellon is both the co-founder and the Bolero and the co-inventor of the Bolero innovative patent. Prior to joining Bolero, Paul was general counsel and company secretary of TT Club, it's a global leading insurer of marine liability. And as a maritime law expert in specializing in bills of lading, Paul is the architect of the Bolero rule book, and it is used precisely present the legal underpinnings of the Bolero bill of lading to us. The following speaker is Marina Komninos. Marina started her career as a trainee solicitor with Clifford Chance in 1998. She was qualified into the Maritime International Trade Group in 20. Her years of expertise include dispute resolution, commodities, international trade, and pollution regulation. Marina joined eDocs on a part-time basis in June 2006 as general counsel, and now she's in a full-time job, also in her role as head of solution delivery since January 2013. And in 2013, she was also appointed COO, and September 18 was named co-CEO. And Marina will present to us the legal underpinnings of the cargo docs bill of lading. And the last speaker of today is Patrick Blochets. Patrick has been a practicing and lecturing maritime insurance and transport law since 1997. He's also a legal advisor of at Cargo X, the company that enables blockchain documents transfer, and is the third company also on our list that have been recognized by the P&I clubs for their solutions of electronic bills of lading, following Bolero and AS Docs. And Patrick is also a former Minister of Transport of the Republic of Slovenia, and it has been dealing with paperless business for several years now. So now, without further ado, I would invite, and he obviously will present the legal underpinnings of the Cargo X bill of lading. Now, without further ado, I now invite Alexander von Ziegler, who then set the stage for the following discussion, presenting to us the provisions on electronic transfer documents in the Rotterdam Rules. Alexander, have the floor, please.
Yes, please. And I hope you hear me well and you see my slide.
Yes, we do.
All right. Well, I start right away by thanking that I can participate in this extremely interesting discussion. I would actually start with reflecting on a truth that we know, that revolution of technology is instantly creating a demand for evolution, if not even a revolution of the law. And this is particularly true for the negotiable document. It was actually the rise of the steamship industry that allowed the merchants to use documents of transport to a higher level and actually to trade them as transport document with a negotiable function. And it was the rise and the birth of the bill of lading that has operated for some decades without any legal input from the legal and the states, because it was law merchant, and I think parties knew how to use it and created that document on their own, and actually the law just had to follow. The problem really was that it was an abuse of the contractual strengths of some ship owners that created the demand to regulate the bill of lading for the purpose of liability only, and that was triggered by the Harter Act in the United States, followed by an initiative of the CMI that had created voluntary bill of lading terms. Of course, nobody adhered to them, so 3 years later, they were converted into a convention. And that is the reason why we have this very strange misnomer that the Hague Rules, which are also, like the Harter Act, basically a liability convention, refer to bills of lading. That it's because they were intended to be bill of lading texts, but they had really very little to do with legislation on bills of lading. Those laws were actually done by the countries. Each state formulated the lex mercatoria in form of national laws. And it is interesting to see that in this wake, one of the first actions of the International Chamber of Commerce, besides issuing also the Incoterms, which are also quite important in international trade, the Uniform Customs of Practices for Documented Credit were first issued. So you see, in the beginning, it wasn't just a maritime invention. It was an invention by trade for trade, where also the banks and traders had a say and wanted to participate in. The next revolution, of course, is in the late 60s, the rise of the container, which has triggered, of course, a lot of challenges to the maritime environment, but also to the other legal environment. Laws had to be adapted. The Hague Rules were expanded to be the Hague-Visby Rules. To be very frank, this is a very slight expansion. 79 is just a monetary expansion. Hamburg Rules were also a sort of a still liability convention. And meanwhile, the container allowed a door-to-door service by the maritime carrier, but it's also the invention of what I would call the NVOCC carrier. That means the carrier that doesn't own a ship, but actually just issues door-to-door documents to the world. This was accepted, was introduced into trade. ICC accepted them into their panel because all of them based basically on national laws that were established for bills of lading, and it could be referred to them more or less, and also trade followed them. It was still an okay world to live in. This is also the time of the rise of multimodality. The multimodal convention was created during that time, all reactions to what has happened. But only 10 years later, another engine has come up. I remember I owned one of them, but it was a clone. I couldn't afford the IBM at the time. The rise of the computer. And actually, that is a huge revolution. We all know that we are faced with developments that are far beyond transport. The whole world has changed. I would say the container and the computer together really have given a great boost to the global economy that we live in today. And actually, we couldn't live without those tools today, and the law had to be adapted. And quite early, and I was a very early CMI delegate at that time, CMI created the Uniform Rules on Electronic Bills of Lading. Really, the purpose was really to say, the current law is also able to answer the electronic version of a bill of lading. This and this has to be done in order for such a document to work. Voluntary basis. It was an attempt to offer something to the market, but of course has not a value of a convention or so, and therefore it is only a little bit an assistance made in the 90s, and of course we all agree is not the end of the discussion. At the same time, or a bit later, of course, and much later, the EUCP were created, but also in the 90s, Incoterms adapted to the electronic trade. So anticipating that this will be a big wake of a new trade, this was made. And UNCITRAL also, in the work on the model on electronic commerce, looked into it and discovered that in particular in relation to the negotiable transport document, there was an issue. Because if you work on the equivalent, functional equivalent we didn't have a harmonized body of law that would give the answers. How equivalent to what? And that is why UNCITRAL at the time invited CMI to look into the issue and potentially prepare a harmonized text that could assist this demand, demand that in the 90s was already around, and which of course increases today, and with the invention of blockchain has become a reality for many parts already today. So when CMI took it on, it was very important not to just jump on the subject, but actually think, what is the bill of lading? What is the negotiable transport document? What is it? And it's not just a contract of carriage document. If we look at just for the industry, it would be totally wrong. The marine industry is just one leg in an entire system that is called trade, where of course we have the contract of carriage, of course, is important. Liability issues will be solved under that. That is fine. I don't want to say that it's not important, but look, this is much more important. It has to be compatible in the entire system. It has to answer the demands of the sales contract. And if I say sales contract, it's just singular, it's the sale contract. But let's be reminded, in trade, we trade the goods. That means that they are on sales, and the document has to survive those challenges. Of course, trade finance, insurance. And I think all of us know that the last point I've raised, namely administrative demands on documents, is most probably one of the hardest to overcome, because they are set by governments in international trade. Now, I just want to go very quickly through those slides. I have shown them before to others, but I want to show that, of course, the contract of carriage is dependent on the contract of sale. It's only the contract of sale that is triggering it, and it will also tell the contract of carriage how to behave in order for the seller and the buyer to have a document and a contract that suits their purposes. So the seller, under many Incoterms, will deliver under the sales contract by delivering the goods to the carrier. That means that in a maritime context, the delivery of the goods to the carrier would at the same time be the delivery to the buyer under the sales contract. So the proof of that delivery under the contract of carriage is at the same time the proof that it had delivered the goods in the sales contract. So that is something that is true for airway bills, consignment notes, whether on road, on rail, and of course seaway bills that also exist in maritime trade. It's not particularly addressing a negotiable document issue, but of course is starting to become an issue, particularly if you think that Mr. B here, the buyer, or Madam B here, is selling on the goods based on that document. So that document needs to be worth something, and the messages in the documents need to be conclusive. So the conclusiveness of those documents already tend towards the negotiability of the document. Now we know that those goods are financed. The buyer wants to have a credit for those goods because the delivery of that document to the bank B will trigger payment under the letter of credit. So the letter of credit function is a huge element, and I think we all are here because we want to see how in the rail environment or in the multimodal environment that can be preserved, and so the documents can be used in maritime or rail finance in letter of credit. If we think of letter of credit, we have to make a differentiation, I think. One is that it triggers payment. I think all of our documents, airway bills, etc., could trigger payment if the parties so agree. So that is not the problem. The problem is when actually the banks use the goods as the collateral for this trigger payment. In that moment, the banks want to have a security on the goods. And that's where negotiability, you will see that maybe the term is overstretched here, but the enhanced value of that document becomes very important. It has to become the key to the cargo. So when Bank A holds the document after having paid Bank B, it has a control over the goods. So the control key is important. And of course, the delivery key is important for the bank. Now, this is reality in maritime trade. And depending on how trade develops on the larger transit route from China to Europe, it could be very well used also in rail transportation. So that is what we're looking at now when we are discussing the transport document being negotiable also in other areas than maritime. It has to be able to be own-sold. This one document, it's just one document issued once, of course, 3 copies usually in maritime trade, will be now used in every of the chain that follow the initial sale. So it has to be apt to give security, comfort, everything, and the key to the ultimate receiver of the goods at destination. So that's the challenge, and that is the challenge that, of course, needs to be translated into law. Now, we have all learned in school and university that those are the key functions. There are different ways to table them. One is the contract of carriage. The other one is the proof of quality and quantity to the goods. They're all important also for the traders. But then comes the negotiability title terminology, which usually is quite different from law to law and country to country, because property and ownership and possession are still things that are very local in law and not that well harmonized throughout the world. And if we break it down more clearly, what we need is a key for the right of control. We need the key requesting delivery. Those first 2 terms do not yet generate negotiability. They just put it on a title level. We call it in the maritime trade so-called straight bills of lading. And when we add the transfer, the negotiability element, we are in the full-fledged bill of lading. And we further break down those issues. You see in the left column all the issues relevant to the carriage of contract of carriage, and then see what the relevant issues are for the other relation. You see that the matrix becomes more complex. And if we look at the laws that are available on the international level, we have to see that only the first top are covered by, I have Hague rules as the most used convention at the moment to show you what is covered. And you see that the rest remains with national legislation. And I can tell you as a litigator that even if we know which law to apply for an issue, and we're already blessed if we have that answer, that the issues can be very tricky in that field, and they are litigated all over the world for different reasons. So when we actually embarked on the Rotterdam rules, we had, and I had the great privilege to be just Secretary General at that very time. So I really had it from the first ideas to the completion on my desk. So I really have the privilege to have been through the whole entire process, also in the first brainstorm of what we have to do. And this is more or less the brainstorm list that was on the table. It was clear from the outset that we had to go away from liability, actually even park liability for a while, not that liability gets in our way. Liability is a very contested issue politically and between industries. Liability is overrated in my view, because 90% of the documents are traded in a perfectly liability-free world, and that's what we have to look at, particularly now. It doesn't mean that we don't have to discuss liability, of course not, but I think we would be doing wrong. We would do wrong to the Rotterdam rules, and we would do wrong to our exercise here if the focus was on liability. We needed to cover the entire period of the custody, so it really was a contract convention that we had to plan. It was a door-to-door convention covering the reality. The reality by the time was a door-to-door market, particularly for the liner trade. And it has to be on Lex Maritima, on the actual customs, how bills of lading are used, on the national law existing. And it had to be covering all the key interfaces to international trade. So if we think in the functionality that we need to translate, those functionalities we really had to look after. That was our task, to provide those interfaces so it could be translated. And that leads us to the last point, which really is the point that the functional equivalent would be possible. And that shows now the list I had before, just translated with the provisions of the Rotterdam rules, that in the context of electronic trade were now made possible to be translated in the functional equivalent. I have here listed the 3 articles that are in the Rotterdam rules that deal entirely on the electronic trade. Don't forget that throughout the convention, there are now references and solutions for the electronic transport record. The first one is that it needs an agreement that the electronic transport record is used instead of a paper document. I think that is clear. It needs to be consensus, and what is important is that it is allowed, that the convention allows it. The former conventions were forcing the carrier to issue paper documents if requested. Then the very important sentence that, of course, everybody expected to have, namely that such a electronic transport record has the very same effect as a paper document. I think that is not a surprise, because that was the very purpose of that exercise. I just have to see for my notes to be in time. I see that it needs to be clear who the holder is, and that the holder has full integrity in the paper. Each time a new holder is receiving the document is received in an integer format. The holder needs to be able to demonstrate that he or she is the holder at that important time. And of course, the maritime consequences of delivery, etc., are feedbacked into the system so that it is sort of closed once the document has been used for delivery. And of course, then the rights in both directions. If a paper document was issued, it can be changed into a record. And also the other way, if it was a record, it can be changed back into a document. I think those were all demands by trade that this has to be done. So that is the answer of the Rotterdam rules. I think that completes my introduction, because basically it is an introduction to the more interesting part, namely how will it be possible to translate all of this into realities. And I close with this. Thank you very much.
Thank you very much, Alexander. And now moving then from, as you suggest, from the abstract world of legal provisions in international convention, which is intended in this respect to have an enabling function. Let's now hear from industry, what industry has been doing to actually make that reality. And let's begin with Paul Mellon from Bolero, one industry that actually was already there at the time these provisions in the Rotterdam rules were drafted. Paul, please.
Hi everyone. I was on mute there. Familiar problem everyone has with dealing on Zoom and Teams. And thank you, Alex, for that really good introduction to what we're going to talk about now. And as you've mentioned, Bolero was being developed at the time of the Rotterdam rules, and it also took benefit from CMI's efforts in devising the CMI rules on electronic bills of lading. Now, I'm going to focus today really on the origins and how we went about determining the structure and how we would make this work. I think we were concerned that there'd be somewhat of an overlap between different presentations for the following speakers. So as Bolero was the first of these commercial offerings, I thought that we should concentrate on the legal underpinnings. So a little bit about Bolero. I won't spend too long on this. Many of you will have heard of it, and it was mentioned several times yesterday. It was founded in the late 90s as a joint venture between Swift, who you also heard of yesterday, and TT Club, which you've heard of earlier, a marine insurance mutual from the P&I fold. And the idea was to create a cross-industry initiative, recognizing that a singular, an initiative coming from a singular set of parties like the banks or the transport companies would be less effective than if they were working together. with the proposal being considered as part of this, as the underpinning of this webinar and the work of UNCITRAL, I'm going to focus really on the bill of lading. The bill of lading is just one of many documents that are used, and we've seen that also in earlier presentations. But it is the trickiest one, and it is the one where the transport and the cargo interests interface with the banking industry, such that the banks can provide at attractive rates, through reasonable processes, trade finance. Trade finance is attractive for banks. It has a number of advantages from capital requirements. So when we founded Bolero, our overall objective was to replace paper documents with electronic documents in international trade. Now, the original mission statement was considerably longer than that. I think pretty much everybody who's listening to this webinar will be familiar with the, how should we say, some of the issues associated with committee drafting. But in essence, that was the overriding objective. And I'm not going to go into the benefits of digitization. I think they're clear. They were clear at the time, and they remain so. And we've heard quite a lot about that already. So our legal objective was to replicate the legal results that users would find if they'd used paper documents. And as Alex pointed out, there's lots of divergence, there's lots of differences in many aspects of maritime trade and maritime practice and jurisdictional differences. But to go there to try and resolve some of those was, we felt at the time, overreaching our objective. So we decided to approach it on completely an as-if basis, so that the parties would have the same predictable outcomes as if they'd been using paper documents. Now, in order to try and make sure that this idea actually was workable, we commissioned a very extensive survey, the first of its type, and certainly, a very large group. And we benefited at the time from being, our shareholders being, effectively the banking industry and the transport industry. So what we did was to conduct this survey with the objective of working out, was it possible? Was it feasible, really? Would a viable product be able to be created? And a secondary but fundamentally important aspect of it was determining the optimal legal structure of that, of the legal solution. How would we best achieve our objective to replicate the legal results? So we used what was called a global approximation method. This, I think at the time, was, I'd been practicing for some time, but it sort of opened my eyes. I think it's a little bit more familiar now, but it's based on the principle that there are a limited number of legal systems around the world, and that those systems share common roots. And what it means is that you can make a reasonable determination of the outcome in a jurisdiction based on the outcome of that question in a jurisdiction sharing the same legal root. So there are 6 principally different types of jurisprudence around the world, and I've listed those out there. There are some countries and some jurisdictions which don't really fit into those, but they're in a minority. And the survey consisted of a number of very specific questions, which we identified as being, key to answering the questions we were looking to, the answers we were looking to get. And a number of those are here. A number of them, the important ones, are here. So, for example, choice of law and jurisdiction. Was there freedom? We were clearly having to use a contractual solution. Was it possible for people to, would courts in different parts of the world recognize a choice of law clause? Would they observe a jurisdiction clause? Would they assert jurisdiction? We looked at writing requirements for trade documents. Were there jurisdictions in which it was prescribed that certain types of trade documents needed to be in writing? The third bullet there, the transfer of property and the goods. Was it possible by means of electronic message? to transfer, rights in the goods. And what we mean in a maritime context is the transfer of constructive possession, which itself is a property right. The next one, which I think is probably key to the work that's beginning here, is would the banks be prepared to lend against an electronic document in a way that they felt comfortable that collateral was equivalent to the collateral they achieved by having a paper bill of lading. And there are then a whole list of more sort of formality type questions about things like, well, it's all very well if the court recognizes these legal principles that we've come up with and the legal structure we've come up with, but are we going to fall at a hurdle where, for example, the evidence of the electronic transaction wasn't admissible in court? So there were quite a few of those types of things that we looked at. So the main challenges, and this is a very, very brief summary of the results, was that it was relatively easy to replicate almost all trade documents. There are certain regulatory documents which were proving, and still prove actually, difficult to put into electronic form. So the e-FITO certificates, for example. There are certain jurisdictions which only want written documents, but that was found to be pretty much in a minority. And I think reflecting the earlier presentation you saw on IATA, there are certain routes which are difficult. Most routes are fairly straightforward. The most taxing document, as was excuse me, as was expected, was the bill of lading, and particularly its function of transferring property. So the ability for you by electronic message to transfer constructive possession of the goods and thereby the right to receive, right to demand delivery. And secondly, but to a lesser extent, actually, the function of transferring contractual rights, such that a subsequent party receiving the bill was bound to the terms and conditions of that bill. So he was not. So firstly, the person had the right to sue the carrier for loss and damage, but equally importantly, that the carrier had the right to rely on his traditional exclusions and limitations of liability under, for example, the maritime conventions that Alex just mentioned. One of the interesting things that we did establish by breaking this down really into sort of minute pieces was that we could separate the transfer of property and contractual rights. So constructive possession could move at a different time or in a different way than the contractual transfer. So it was perfectly possible, and this is important in a banking context, that the bank could take constructive possession of the goods by virtue of holding the electronic document without necessarily becoming a party to that contract. Now, if there was a default or an issue which meant that the bank needed to enforce that security, then of course you would have to become a party to the contract of carriage in order to demand delivery of the goods. But it's an important distinction, and I think one worth considering in the context of the work on making multimodal or non-maritime transport documents transferable, that this can be separated. Now, what we did determine was there were effectively two ways in which we could deal with the transfer mechanism, and that was assignment and novation. Novation was relatively new to me. I, at that time, was principally on working under UK Carriage Goods by Sea Act, which had brought in statutory assignment after many years of litigation about how exactly the rights pass from one party to another. But we did discover that in certain civil law jurisdictions, the writing formalities for assignment were actually much trickier than they were for novation. Novation being a Roman law principle, that there were relatively few formalities required for novation to work, and that moving those messages performing the novation could take place electronically. Now, as a consequence of that, and this we were developing at the same time as the technology to do that, and they work hand in hand, was that we devised the contract you've heard it referred to as the rule book. This is a contract that all of the users of the system are required to sign up to. It really sort of governs many things like rules of the road, what's the significance of a message and those sorts of things, which are fairly generic. But more specifically in the context of what we're discussing now, it prescribed the process and legal underpinnings of and what the legal result was of parties performing roles in certain functions. And the next slide, which is actually an extract from the rule book, I know it's sometimes seen, and probably the clause in the contract that I'm asked most about, as lawyers are not used to really seeing matrices. And this is a matrix which is contractually part of that multilateral contract, which prescribes the functions that a party can perform according to the role he's performing at that time. Anyway, I won't go through that. I mean, it saved an awful lot of space in written prose, I have to say that. Now, some of the challenges for adoption, and I'm sure Marina and Patrick will talk a little bit about this later, but the principal fetters, the reason why, I mean, this is a substantial business. There are a number of operators, and there are a growing number of operators coming into the space. There is certainly business there, but the reason why it's not moved into widespread adoption, so it's mass market, so we don't have the same mass market penetration as the air industry for airway bills, have been commercial and organizational rather than legal. So it's an extremely complex, multifunctional, and global. So there are lots of different parts, different moving parts involved. Digitization, as we've heard, does create benefits, and I believe that there are benefits for all participants in the trade chain. Everyone's getting involved, but those benefits are not necessarily equal. So one of the principal benefits for a seller is that he can present his documents under a letter of credit, for example, and be paid much more quickly than he would do if he had to gather together those paper documents. And that means that somebody, if somebody's being paid earlier, someone's paying earlier. So there are those sorts of issues. But again, the main competitor for Bolero, and I think for others, is inertia. That this is complicated. Let's wait and see. There are, sort of as you heard yesterday from the ICC, from Oz, there are other challenges that need work before this goes mass market, including standards and the interoperability of the systems. We're moving quickly on to some of the legal impediments. Again, this is it makes it sound a bit sort of divisive. The larger corporates, carriers, and the trade banks are able to understand the contractual solution very quickly, and they can see. They have their legal departments. They can analyze the legal risks. There are certain conservative jurisdictions where formalities were and remain high, where the recognition of the documents could create an issue, i.e. there would be a risk on either a choice of law or a recharacterization of what we would say was a substantive provision in the rule book into, no, this is my court and I have my own rules on evidence. I'm going to apply that and I don't care what your contract says. But relatively speaking, those risks are small, and they recognize, the larger organizations recognize the benefits are substantial. They also recognize that there are substantial risks in dealing with paper. It's not a zero-sum game. It kept me in good employment for many years, and the maritime bar is still very busy. Smaller organizations tend to look for more certainty. They are looking for either legislative support, government promotion. And again, in the context of law, one of the frequent questions I get asked is, have there been any decided cases on this? As far as I know, there's been no litigation involving this. It's not been challenged in court. And just as a sort of a final sort of message from me, it's really important to drill down into what functions the document's performing. Shorthand descriptions like document of title, negotiable instrument, negotiable document, these are not usually helpful. We need to look very clearly about what the document does. And from my perspective, they confer the right to a negotiable transport document, a transferable transport document, rather, can confer the right to delivery. So if you have exclusive control over the electronic record, then that gives you constructive possession, and that translates to actual possession when you can demand delivery from the carrier. The other reason that this is important, and particularly important in this context, is bills of lading are not negotiable in the same way as a bill of exchange. And as a consequence, maritime lawyers and banking lawyers are sometimes at cross purposes on some of the important details. So as I say, it's important to drill down into what exactly it is you're transferring and what the effect of that transfer is. I won't talk about this. This is something you can perhaps have a little look at. I think the presentations are going to be made available. But I'd like to conclude by thanking you for your patience, and I hope I've given you some food for thought. Thank you very much.
Thank you very much, Paul, and especially for the connection established between the abstract principles we've been talking about so far and the enabling legislation as such, but what actually the practical obstacles exist for the implementation of these systems. You did provide ample food for thought, and I think we're going to have the opportunity to discuss that and the Q&A session. But now let's move straight on to Marina for her presentation. Marina?
Good afternoon, everybody, or good morning, depending on where you might be. I hope you can now see my screen. It is a great honor and privilege to be here. So thank you very much for inviting me, Jose, and the rest of the UNCITRAL team. I wanted to talk a little bit around the interplay between our legal frameworks that Paul has spent some time talking about, and the legislation that we're seeing come into play more and more as digital trade takes on a more important focus, I think, for a number of governments. So I think we are seeing digitization increase at an unprecedented rate. Even shipping and trade has managed to catch up. We're last of the Mohicans usually, but I think that we are getting there in terms of digitizing. And the pandemic, the ICC has estimated that the pandemic has probably accelerated digital trade for between 5 and 10 years. So while we don't see huge penetration rates in EBLs, the DCSA has said that penetration rate in liner is probably less than 0.1%. We do see much higher penetration rates in metals and minerals markets than that, but certainly there is no doubt that EBLs are not where they should be in a digitized world. And one of the reasons for that is legal uncertainty. We cannot avoid that conclusion. There's a number of different people in different jurisdictions where it is felt that the contractual mechanisms that we have taken as solution providers aren't adequate to support a fully scalable EBL solution. I totally agree with Paul that there's a number of other factors that influence our ability to scale, resistance to change, change management, etc. But certainly there is a perceived, at least, risk of legal uncertainty, which is a blocker to broader adoption. So what is that and what can we do about it? I'm not going to replicate what Paul said, so fear not the next 5-10 minutes that I speak to you. But what I wanted to say about multilateral contracts is that they replicate the rights and obligations under a paper document by providing legal mechanism tools in which ensure that you end up with the same rights under an EBL as you would do under a paper bill. And they do that by creating a club of users, all signed up to the same contract, a multilateral contract, which promise each other to treat the electronic bill as the equivalent to paper, making it essential that everyone signs up to that multilateral contract in a valid and binding way. So that's one way of achieving EBLs. The other way of achieving EBLs is national legislation. Much, much simpler, of course. I'm sure most people on this webinar will have heard that Singapore enacted the Electronic Transactions Amendment Act this year. It went into law in March. The US has had similar legislation since 2003. And of course, legislation has the ability to decree, essentially, to just say that EBLs are the equivalent of paper. It doesn't need those sort of legal mechanisms to achieve it. It can just say, this is what we say under US law and the Singapore law. So how can those two concepts live side by side, a contractual framework and enabling legislation which allows for electronic bills of lading? And this is where we come to a little bit of a challenge of enacting legislation. I'll say this at the outset, I'm a huge fan of the UNCITRAL model law. I participated in the UNCITRAL meetings, the drafting meetings. It was an incredible experience. I think it's a great piece of legislation. So don't read into this slide around challenges that I don't believe that is actually the way out of some of the legal uncertainties we have. It's just a journey. And the reason it's a journey is because, by definition, international trade is cross-border. So the fact that one jurisdiction may have recognized electronic bills of lading, be that Singapore or the US, it doesn't mean that an English law governed bill used in a trade from the UK to Singapore, to Spain and financed, for example, by a Swiss bank, is going to be enforceable itself. So we need to think around scalability. When you look at scalability, you need to think around, well, which jurisdictions is this going to touch and where does it become relevant? Disputes under a bill can arise under different scenarios and under different jurisdictions and with different contractual relationships. And so hence to my next point on this slide, where you may think that I forgot to take the square brackets out of that paragraph. I didn't. Essentially what I'm saying here is that I think there remains a need for contractual frameworks to support EBLs until bleep, choose your preferred option here. Enough trading nations have adopted the equivalent of the model law, or EBLs have become custom of the trade. Which of those three, enough, the majority, certain, key, is the correct one? I don't know. How long could that take? Personal view, not an SDOX one. I think it's a minimum of 5 years, but we have seen a huge acceleration in the way that governments are approaching digitization, international trade. There's a lot of focus on it right now. And so I would be pleasantly surprised if it's quicker than that. Just an add-on to that. So why can't EBL providers just use a law like the Singapore law under their contractual frameworks? And that would be much simpler than the quite complex novation and attornment mechanisms that Paul alluded to earlier. Now, the reason that most of us use novation and attornement is that we don't want to rely on one nation's laws to create that concept of functional equivalence. I.e., we don't want to be saying that our convenants, for example, EBLs, are valid because US law says they are. The concern there is that other jurisdictions may struggle to simply accept that because US law says it, it needs to also apply in their jurisdiction. So what we use instead are certain tools to contractually recreate those rights and obligations, because the tools are more widely recognized than someone else's law. And so those tools allow a court in a foreign jurisdiction to say, oh, I understand you're using novation, and novation makes sense to me, so I think that this works. So that was the rationale for using these contractual tools. But is there a way to use national enabling legislation, such as the US UCC and such as the Singapore Electronic Transactions Act, and the contractual frameworks together to provide people greater certainty, and therefore really everyone's desire to push for greater adoption? There certainly is. And from the outset, the SDOC's legal framework, which is summarized as the DSUA, has always had that dual mechanism. So, as I mentioned earlier, the UCC in the US has recognized EBL since 2003. And so in our first approved version of the DSUA in 2009, we said that if an electronic bill of lading created on our system is governed by US law, then transfer of the rights and obligations under that bill will pass in accordance with US law. We don't need to rely on novation and atonement. It's a US law governed bill of lading, and US law will govern how those rights and obligations will pass. In other cases, novation and atonement works. Since the passing of the ETA, we've done an amendment to our DSUA, and just this week we got IG approval for an updated version of it. And what we've done is said, well, actually, we now have the Singapore Electronic Transactions Act as well. So then it's fine to say that any electronic bill of lading created in our system, which is subject to Singapore law, does not need novation and atonement to support the passing of rights and obligations through the trade chain. Singapore law should be responsible for ensuring that passage of rights and obligations. We've also extended the DSUA to allow for Singapore jurisdiction, which, if all parties to the dispute have elected Singapore, then it will make it much simpler to have a Singapore court deal with any issues arising. So that version of the DSUA is going through a user review process and will be effective in the coming weeks. But I think it gives a sense of how there can be a legitimate and useful interplay between contractual frameworks and the legislative process we're going through. You'll be happy to hear I've come to my conclusion slide. As I said, a big fan of the UNCITRAL model law. It's key to overcoming legal uncertainty and to ensuring that we can achieve legal interoperability for ETR solutions. And I think interoperability is really where everyone is and should be heading. Governments are looking at implementing legislation much more closely than I think they would have been had the pandemic not occurred. So silver linings, as always. And contractual frameworks can and should work with implementing legislation until such time as they're no longer required. We'll always need terms and conditions which regulate users' use of our solutions, but there's a difference between sort of terms and conditions. These are the rights and obligations of us as users of the platform versus I need to create a legal framework for recognition. So on that note, I will sign off. Thank you very much. I hope that and I'll hand over back to Jose.
Thank you very much. Thank you very much, Marina. I think it was a wonderful presentation, and also not only for the nice words to UNCITRAL, but also I think it complemented nicely Paul's presentation, and I think also provides us a leeway for the next one. I already have questions in the chat, but I'm reserving them for the Q&A session at the end. Now, may I invite Patrick to make his presentation?
Okay, thank you very much. Thank you, Jose. Thank you. First of all, I would like to thank you for inviting us to the UNCITRAL webinar, especially since we are with these two most valued companies, Bolero and ESDocs. I hope you hear me because I don't see you anymore.
I can hear you, Patrick. Perhaps if you could close
the
microphone,
okay,
because there is some noise on the line.
Okay, thank you. So the first slide is actually a brag because we had this idea of exchanging bills of lading by using the public blockchain. It was quite a challenge for us, IT experts, logistics people, and lawyers. We had to come up with a system that we now call blockchain transfer of documents. Well, we say that this system is 100% secure and that it reduces costs and it works instantly, especially in comparison to the traditional courier service, as you may see later in the short film that we prepared, because we are much younger company. on the market, so we prepared a short movie to see how it works. I hope it will be interesting for the people to see. It is quite user friendly, I suppose. And obviously, at the end of the day, what we prefer to present ourselves is that we are a modern courier service. A lot has already been said about the history of e-commerce and also about electronic bills of ladings. So I won't repeat it. What I would like to emphasize is that I sincerely wish that UNCITRAL model on electronic transferable records from 2017 will have best of luck on the road. Hopefully it will be like MLEC, which was very successful. And my second wish is for the Rotterdam rules also, that will maybe meet the same fate as did the PAL protocol from 2002. When the latter took by the EU under its wing, it gained the momentum and it became important even on a global level. So the protocol, which was almost doomed to fail, is now a part of EU rules, and now it's back to life. So, as I said, CargoX offers blockchain documents transfer, and our electronic bill of lading mirrors the paper workflow. And this is also one of the questions to be asked in the future. Does it really make sense to mirror the 14th century workflow? Or is it possible to do something that would be completely new with the new features that are offered with e-commerce? The main challenges are, as it was said many times during these 2 days, uniqueness and originality. And we are achieving this through the distributed blockchain ledger rather than centralized administrator. Here are some of the features of CargoX. You would just need the browser, and we also offer the tracking of documents, audit log, digital repository. It is interoperable, and obviously we can be used as a platform for different types of documents. Here are a few words about blockchain, which I will not talk about because you already know about this, I think, enough. Why we choose the public blockchain? The main reason is because it is neutral. That means that the public blockchains eliminates the need for trusted gatekeepers. It is open to the public, and anyone can join without any special permission. And it is decentralized. There is no single organization that controls the ecosystem. And you might remember the NotPetya malware from 2007, which was a very, very big attack, also suffered by Maersk, and the consequences were, as we remember, very, very problematic. Just to say a few words about what we see as a legal challenges. Here is what I think. In just a moment, I will show this picture, which is not so beautiful as Alexandra's pictures before, but this is actually one of the things that I think that is one of the main problems. The blue one is the contract of carriage, the yellow one is the contract of sales, and obviously we have so many participants from different legal systems, from different industries even, and this slide is showing all these stakeholders that are in these two contracts, and these different players with different backgrounds are using this bill of lading, and they all have to agree that is dematerialized. Yeah, and it is just one of them is not into e-transfer. The party is over, and then the question arises: which participants actually has a right to demand the paper bill of lading. So any one of them can demand the paper bill of lading because it's actually a private document. And sometimes even in some countries, the customs demands the paper document. Sometimes the bank demands the paper document. So these are the challenges that are not so deeply legal, but are more superficial. But still, if somebody demands the paper document, we have to go way back and just issue the paper document. So we have this B2B, parties of the contract, issuer to shipper, shipper to the next beneficiary or consignee. We have seller to bank, we have shipper or seller to insurance company sending LC. And all this, the bill of lading, all this transfer could with no problem be electronic. But if just, as I said, one of these companies does not want the electronic document, then we have a problem. And that also is a problem with the customs, which in some countries demands the electronic documents. I have prepared the short movie, just a moment, to show you how it works. Yeah, okay, I hope it works.
Welcome to the blockchain document transfer demonstration on the CargoX platform. First, let's go to cargox.digital and log in using username and password. While I am logging in, I kindly invite you to open a CargoX account for your company. It only takes 2 minutes and is free of charge. You can access CargoX platform through web browser on any device, from computer to smartphone. It works everywhere. All you need is internet access. Our open API allows interested companies to integrate all CargoX features into their IT system. CargoX platform supports over 50 document types and is very flexible. In this short demo, I will focus on the sea freight and global trade, as I am currently logged in as carrier, who will create and send a digital bill of lading to the shipper. Let's compose a new digital envelope to start. First, I will select a recipient from the list of all companies that I am connected with. If I would need to send documents to a new company, all I would need to do is enter their email address. After they accept my connection request or register their CargoX account, they would appear in my list. I can either upload the documents from my computer or select them from my CargoX inbox if I receive them over the platform. Let's upload them from the computer. I can upload multiple files at once. Now I need to select a document type for each uploaded file, so I click Properties. I start typing the document type to quickly find it. Some document types, for example, bill of lading, require additional information, which I enter below. I also need to select the agent who will accomplish the document and release the cargo at the port of destination. Let's repeat this for the packaging list. CargoX platform supports over 50 document types, so let's scroll down to find the right one. With my documents attached, I can write an optional message for the recipient here at the bottom. My envelope is now ready to be sent. Once I am ready to proceed, I click the seal button. This creates a digital fingerprint of all documents and encrypts them. Now a new action becomes available. Once I am ready to send documents to recipient, I click the transfer button. In the overview screen, I can see which documents I am sending to whom, how much it will cost, and who will pay for the transfer. Before I can transfer documents out of my CargoX account, I need to digitally sign them with my personal cryptographic blockchain key. To do that, I first need to unlock my blockchain key. With my key unlocked, I am now ready to digitally sign the transaction. On the Cargo X platform, document transfers are executed only once the user digitally signs them. No one else can do that on behalf of the user, not even Cargo X. Documents and their ownership title are now securely transferred to the recipient with the help of the blockchain technology. Transfers are always direct, without an intermediary. Delivery is completed within a few seconds worldwide. To verify that documents were really delivered, let's click on the Sent folder and display the envelope we have just sent. Documents are tracked real-time independently of envelopes. We can see that I have issued this house bill of lading as carrier, but that document is currently in the hands of the shipper. If I open the document, I can also see the watermark, which visually informs me that I am no longer in possession of the original document. We can see the status as delivered. In the audit log, I can see who and when created the document, and when the title of the document was transferred to the recipient. I can see which employee endorsed the transfer with his digital signature. Best of all, nobody needs to put their trust on the Cargo X, as all transactions are recorded on the public blockchain where they can be independently verified. Here is the corresponding public record of our document transaction. General public can see only that a random Cargo X document token changed hands between two anonymous blockchain addresses. A digital fingerprint data that can be used to verify the authenticity of the received document is recorded below. The audit log can be downloaded as a PDF and used as proof of transaction. The audit log grows with each consecutive transaction, forming an unbroken chain of transactions for full visibility and for transparency towards governmental authorities. Speed, safety, and cost savings are just some of the benefits that Cargo X brings. Thank you for your attention.
Okay, thank you. I hope you've seen what was in the movie. Maybe just a few words about the legal features. We made it as simple as it was possible. In Cargo X, the terms and conditions constitute an agreement between the users and between each user and Cargo X, acting mostly on its own behalf and sometimes on behalf of other users when this is in need for innovation, for example. The parties agree that an electronic signature on DBL has exactly the same force and effect as a handwritten or printed signature on a paper BL, and that electronic BL is exactly the same as the paper BL, that it has the same force in law. So actually, what we are saying that it is a private document between two parties and Cargo X with its role in between. Maybe just brief description of business model. It is prepaid system model. The payment for using Cargo X is usually in US dollars or in euros. The usual price is 15 euros per BL, payable by issuer, or there is also pay to collect option. All subsequent transfers are free of charge, and that is everything that somebody has to pay when it's using our system. Maybe these are some legal questions for future that were already mentioned before. One of the questions that we see sometimes from companies or from banking sector is should we or are we able to do KYC? The other one is questions from the different companies. Is EBL valid document in all the states? And then the question, what should the holder of EBL do if the authorities in certain countries do not accept EBLs? And obviously interoperability of EBL providers. Thank you very much. I will be very happy to answer any question.
Thank you very much, Patrick. As a matter of fact, we already have questions, two questions that were asked through the chat, and they're asked before we made our presentation, but I would assume that those people asking those questions would also have to address them to you. And I have a few questions on my own that I'll be asking afterwards. So the first question is, it's actually addressed to all panelists as well as the moderator, if possible. And I read the question: so far, UNCITRALs and other conventions on the contract for sea carriage of goods have only addressed evidentiary effects, and the Rotterdam rules, the transfer of contractual rights under negotiable transportable documents and bills of lading. Should or would a new instrument address also the effects of negotiable transport documents with regard to property, including security rights in the goods? Yesterday, we've heard that this is not crucial for seller and buyer, but today we've heard that this may be important for banks. That may be interesting, possibly useful in the market, but also may be quite a challenge. I would use my prerogative as moderator to answer immediately as far as we are concerned at UNCITRAL on that question. Sorry, there's some echo. And the proposal, as was tabled by China, was to develop transferable multimodal negotiable transport documents. It was not so much concerned with what is the proprietary effect of that document over the goods as such. So the idea from the way we understood is that we should not go beyond simply clarifying that this multimodal transport document could also be transferred. And by transferring the document, you'd be transferring the right to claim delivery of the goods and exercise control of the goods along the lines of what is done by the Rotterdam rules. We never understood the Chinese proposal as one that would try to also unify property law in respect of goods under a contract of carriage. We know that there are disparate solutions for that under domestic law, but we had not understood that this was the intention of the Chinese proposal. Now, with that explanation, at least from our reading of it, now I give the floor to the four speakers to address this question. I repeat again: do you think a new instrument should address this? And so, Alex.
Yes, thank you for the question. I think that was a question that is constantly on the table when issues of interfaces between rights and then the proprietary rights are concerned. And the tradition so far of all international organizations which were faced with this issue, whether it was UNCITRAL when regulating CISC, so the sales convention, or it was ICC looking at Incoterms, or Rotterdam when we looked into it, was really to separate one and the other. I think the problem that we saw in all those is that, and it really appeared even if we wanted to discuss the pledge of the carrier over the cargo for not receiving its fees and freight and hires, as soon as we are touching upon property or possession, countries are very reluctant of entering into any harmonized system, touching upon what they regard as one of their ultimate national law prerogatives. And it is not necessary. I think as pragmatic as the industry is, and I'm very grateful for the presentation showing that actually the industries are so much more important than the law, because they're actually producing the tools that would give all that comfort. But I think it is sufficient to allow those instruments and triggers. I think to provide them clearly, to provide them harmonized over the globe. Therefore, I think that it would be very important to, in the maritime sector, to actually have the Rotterdam rules really in place all over the globe. And I think it should be very one of the focuses to do that, so that at least in the maritime sector, we would have that match. Of course, the rest would have to be done by the industries providing those electronic systems, but at least the paper system would be clearer than today. So I think that this is one of the answers we can give. I think we would really be doing something wrong if we put issues of possession, property rights, and even ownership on the same desk. I think it's already enough to be dealt with when we want to create a document that is negotiable, and for instance, for the rail transport or for any other transportation. Thank you so much.
Thank you, Alex. Paul?
Well, I agree with Alex. I think taking this further, going into property would be a bad idea. So I think that there are challenges enough without trying to extend, and I think I'm not sure it's achievable, to be honest.
Yeah. Thank you, Paul. Marina?
Sorry, I won't bore the webinar with a similar answer. Touching into substantive law is only going to cause a lot of pain, and you'll never get the sort of unanimity you need. So I would steer clear of it, because I think that what we need is an easily adoptable instrument. We don't need a complex delve into substantive laws.
Thank you very much. Patrick, would you like to add anything?
No, I just agree with what you said, Jose.
Thank you. And this has been our understanding, that the Chinese proposal was a pragmatic one. And I mean, as long as you establish the entitlement of the holder of the document to claim the delivery of the goods and to control the goods during carriage, whatever conceptual connotation that has under domestic law would be left for domestic law, and we would not need to deal with that. Now, the next question that we had here, and this is Regina Azariotis from Untitled is addressing this question to Marina and Paul. Maybe also Patrick would like to add anything. Thank you for the interesting presentations. One question: could you please let us know what liability provisions your electronic bill of lading systems envisage in case of technical issues leading to errors in transmission, delays, causing a loss, etc.? I think I do remember the liability provisions in the Bolero rule book from years ago, but would you like to start? Marina, why don't you start?
Happy to. So SDOX takes liability of $20 million per bill of lading for what we call e-risks. That covers e-crime and e-failure, and that's covered by an insurance policy whose primary underwriter is AIG.
Thank you. Paul?
Yeah, we also accept responsibility if there's an error or problem in the system, and we have substantial insurance to meet those liabilities.
Thank you. Patrick? We can't, you're muted, Patrick.
Yeah, sorry. We also have insured our liability in one German insurance company. It's substantial, and the law that we use is English in this case of our liability. Everything that is connected to bill of lading is English law.
Okay, thank you, Patrick. And the next question is addressed specifically to you. Question from Toji Takahashi from Japan. The model on electronic transport of records requires ETR management systems to be reliable. Which specific public blockchain is your system using? Ethereum, EOS, or another? How do you think you could convince the lawmaker of the reliability of that blockchain, which is by definition not administered by anyone?
Yeah, we use Ethereum, and yeah, this is actually very interesting question. If we go back in the history, the trust in the first bill of lading in Genoa was in paper. The trust in Maghrebi traders were by person, because they were sending the person with the cargo, with the merchandise, to secure that the merchandise get into right hands, in the consignee's hands. Now we have this net of thousands and thousands of computers that have blockchains, which secure that the document is unique and original. So this is the answer. We have to have this trust into public blockchain. Only maybe some catastrophic moment that something falls on the earth, that the system will not work anymore because there will be no power, would be something that would crash the system, as it seems to me. So this trust has to be earned, obviously. But as it started with a document in Genoa and with Maghrebi traders, with the persons accompanying the cargo, now we have to trust the public blockchain.
Thank you. Actually, that leads me to, the comments just made lead me to a question that I'd also like to ask the participants. Actually, two questions. The first is a more general one. Would you, from your perspective, how would you receive the development of a new instrument only to support the use of negotiable multimodal transport documents also in electronic form? Would you think that this would provide further encouragement for the use of your current business solutions? That's the first question. Would be something that would be supportive of what you're doing? I think Marina already gave a hint of what her views of that are, but it would be interesting if I could hear from all of you. And then the second aspect now related to the question that was asked to Patrick on reliability. All UNCITRAL instruments have used this phrase that they have to use a system in order to establish functional equivalence. We have to use a system which is as reliable as appropriate for the purposes. And then you have this two schools of thought. Do you have an ex ante or an ex post mechanism for determining reliability? You know, an ex ante is like the advanced signatures for electronic signatures, and ex post is when you allow to a judge, for example, to assess the reliability of a system on its own merit and not because it's on a state list of reliable systems, right? And UNCITRAL instruments have always accommodated both solutions, both the ex ante and the ex post. Now, to come to directly to my question, would you say it workable also to have an international system that along the lines of also what is in the Rotterdam rules and also in the protocol, the e-protocol to the CMR, would basically rely on the existence of system rules and say, as long as you have system rules that provide for ABC, then you have a functional equivalence, without getting into the details of how this system rules should look like. And simply saying, if they're as reliable as appropriate for the purpose of establishing the uniqueness and integrity and originality of documents and exclusive control, that this will be the standards, and that any instrument should then not get into those details and allow the judge then to determine afterwards whether the system chosen by the parties is a system that is as reliable as appropriate for the purpose of creating an enforceable, transferable, multimodal transport document. Now it's over to you. Would like to start?
Shall I start with the first question? I think I'm the wrong person to answer because it should be the market really, and really the shippers, the banks, and the receivers that should answer. But I think from my understanding, it's the following: you would need the title-esque kind of character on the document as soon as you need the document as a tool to secure payment. So the seller who is not that sure that he will be paid, of course, would like to have a document in order for him or her to retrieve the delivery under the stoppage in transit, Vienna Sales Convention. As soon as you have a situation like that, the demand will arise. It also arises in the cases where the recipient of the cargo actually wants to have a credit line between the delivery of the goods to the carrier, railway carrier, whatever carrier, in the place of shipment, and this credit needs to be secured. Now, you can do this with own collateral, but of course, this will reduce your liquidity and your possibility to function in your country. So what you want is a credit from the bank based on the value of the cargo. As soon as you want that, I think the demand is there for such a document. And we always understood when we listened to the merchants and the importers and the banks in, for instance, China, that because of the length now of the transport, we're talking now of 17 days or more for the transport chain, the pure chain of transport, that gives a huge opportunity to actually use this time, not only for that purpose, but maybe even for negotiability in its proper sense, that actually could be now traded, the cargoes from one entity to the other. One would be fronting the purchase and the other one will do then the resale into the market in that country. So I think there is a demand. Of course, it should be answered by people in that market, but as I understand, there is a demand. And if there is a demand, I think the question should be on our table to answer it.
Thank you.
I think from Bolero's perspective, we'd be very interested in supporting an extension of that. By definition, the cargo that's coming from China to Europe on that long rail service is going to be relatively high value cargo. Otherwise it would go by ship, which takes quite a lot longer. So the advantage of speed means that the highest value cargo will be moving by train. There's a huge demand for supply chain finance, and there's a huge demand by providers of supply chain finance for additional collateral to support their transactions. So yes, we'd be very interested in doing that. We would support that.
Thank you, Paul. Marina?
Jose, I'm going to focus on the second part of your question, because I think that as you correctly identified, I'm a big fan of the UNCITRAL type streamlined laws. I think in terms of reliability and the concept of how much do we build into legislation versus how much do we leave for the market to determine, and then is it a court that needs to determine or an auditor? I think it's a very, very loaded question, and one that we certainly spent quite a lot of time talking about when drafting the model law on ETRs. For me, the critical thing for adoption and for users is certainty. They need to know that when they're using their EBLs or their bills of exchange or their whatever it is, they need to know that they are valid and binding. They don't really want to say, well, I think they're valid and binding, but I don't know until I get all the way down to the end of the chain and I end up in a dispute whether actually I'm using a bill or I'm using some sort of fabrication that's an electronic data set. So certainty is critical in that. There has been a movement within when enabling legislation has been passed to create a concept of audit for providers, which I think is reasonable. What I have concerns around in that area is audit requirements at a national level, which may vary from nation to nation, but which solution providers then need to comply with each of those individually, and there may be conflicts between them. So while I think that sort of concept of ensuring reliability through standards is very important, it needs to be very carefully constructed such that it doesn't actually just hamper adoption. It creates a vehicle for broader and quicker adoption.
Thank you. Thank you. Let me just.
I'd echo those comments.
Yeah.
You might find a situation where, you know, so Singapore enacted some regulation that everyone had to comply with, and where the goods were coming from hadn't. To me, it lends itself to suggested this to the ICC that they might want to pitch in and provide that a uniform accreditation, which would certainly speed things up.
Mm-hmm. Mm-hmm. You know, I'm asking this question because one of the issues that comes up again and again is this issue, you know, the dichotomy between the closed system and an open, so to speak, negotiation system. And people saying, oh, as long as you're in the cozy closed environment, everybody abides by the same rules, everything is fine. But if you're trying to move towards allowing negotiation of goods, you know, and as in this case, you might then ending up with a consignee which is outside that club, and how you make that, you apply the rules to that person. I would have thought that if the main gist of the proposal by China was to provide collateral is primarily within the framework of documentary credit and letters of credit, then the banks would be participants in the system in most cases, and that would not by itself be an issue. But if Alex is saying, well, perhaps then we, in this brave new world, we also then should be catering for negotiation of goods in transit, then you're opening the door for, you know, a different, you know, a different horizon of people that one have to consider as well. I have here one, I don't know, Patrick, do you want to say anything to that, or should I move to the next question?
Oh, you can move to the next question.
We have only one here, one question about your systems. Are your systems interoperable among themselves?
Currently not.
Currently not.
Currently not, but that's a piece of work that Oswald and the ICC are working on. The DSI is looking to see how you know, whether and to what extent the systems can become interoperable. But that's definitely a work in progress.
Okay, thank you.
Yeah, I mean, all I would say on that, Jose, is that the challenge is not a technical one. I think interoperability at a technical level between our various solutions could be relatively easily overcome. The question really becomes around legal interoperability, and each of us having our own club, so to speak, of users, and how can we create a bridge between those legal frameworks.
Yeah, I agree. You start with one terms and conditions or rule book, and you go into another one. This is the question.
But if that is the case, then could it also be that if you had an overarching system that gives legal certainty for the use of electronic equivalents of transport documents, that could also ease legal interoperability, right?
Well, we could do it by private agreement. I mean, there's a certain sort of metadata. There are a limited number of functions. I showed on my slide that matrix. There are a limited number of functions you can perform with a bill of lading or with a transport instrument. So it's mapping those to, you know, the respective solutions. Meta rules, yeah.
Very good. We have 3 minutes left. So I mean, would ask if any of you would have like to make a final statement, or perhaps any of the speakers in the previous panel would like to make that, say a few words before I close.
I think it's been fascinating. There's been some very interesting presentations, and I just thank you for inviting me to participate. I think this has got some legs, so we'd be very keen to continue to work with you in developing it.
Well, thank you, Paul, for your kind words, and it's a pleasure to see you again after so many years. And
yeah,
I mean, also,
long time.
Yes, to realize that I'm not the only one who got grey in the meantime.
Oh, thank you.
So now with that, I think, again, that all participants would also agree with me that we had two excellent panels this morning, and I think we have a lot of food for thought, but also in particular, I think we have many very solid, good ideas for on the electronic aspects to add to what is currently on our table to realize this proposal. As I mentioned in my earlier remarks, and also the UNCITRAL Secretary mentioned in her remarks, UNCITRAL has put this already on the work program. Our horizon in terms of timing would be that if Working Group 6 on judicial sale of ships finish its work in the fall 2022, that this will be then the next round of intergovernmental negotiations would be addressing this starting in the spring of 2023. And I think what we heard today and yesterday confirms that there is demand for this project, that the proposal by China is a timely one, and that we have ample experience in the market also ready to suggest possible solutions in terms of what this instrument should contain to address not only the transferability function of multimodal transport documents, but also in particular, as we discussed today, the electronic aspects. And with that, I think all participants are also joining me in the round of virtual applause to our speakers. I thank you all for your interest in this project. We are, of course, remain to our disposal for any questions that you can have. You can reach us through the UNCITRAL website and email address. And with that, I thank you all for your participation, and I close this webinar. Thank you very much.